as far as I understand, you have some expertise in the world of medical technology and biotechnology. First of all, what is the difference between those two?
So, from my perspective, medical technology focuses a lot more on medical devices, things that are used in hospitals, whereas biotechnology is a different type of what we think of as medicines or drugs or treatments. Biotechnology is more comparable to drugs in the sense that can be either small molecules or biotech. And it typically comes down to the way something is approved through the FDA.
And which one do you have more experience working with?
Biotechnology, but throughout my career, I've worked in a number of different technology areas. And I would say earlier in my career, more focused on medical technology, and later in my career, more focused on biotechnology.
Okay, great, because I have questions about both, so that's perfect. So would you mind just going through a general overview of how the law and medical technology overlap? So from what I understand, there's the design process, there's patents, which are the most popular area that the law intersects with this field, and then regulatory approval, sales, marketing, and maintenance, all of that. Can you give us a general idea of how big of a role those ideas play in somebody that might practice in this area?
Sure. So, intellectual property, as you mentioned, is a key area for this. And most medical technologies are protected through patents and patent applications. It's really important to be familiar with the rules of patenting, especially what can stop you from getting a patent. For example, if you're an attorney and you are working with a university client, and that university client has a new medical device that they have invented and are seeking to have you file a patent application on, you'll want to know what questions to ask to make sure that they have not already done something to prevent a patent application from being filed. For example, disclosing the invention publicly before the filing of the patent application. Also, there's a lot of commercialization work that goes into developing biotechnologies, and this can look a lot like partnerships between different companies. It can look like license agreements between universities and companies. It can look like co-development agreements with the government. So contracting is an underlooked but huge part of the commercialization and development of medical technology. And then farther down the line, you do have the regulatory path. You will need to know what path your technology needs to go through in front of the FDA or abroad if you're seeking to go international. You'll need to know what kind of clinical trials, if any, you'll need to prepare. You'll need to understand the rules around those clinical trials. And then you'll need to know how to present that data to the FDA. And then further along the line, you'll also have monitoring, and you'll need to be sure that you are complying with the FDA rules on the back end once marketing approval has been granted.
So at what stage of this entire process do lawyers get involved?
Typically, as soon as the client is aware that there's an invention. There may even be a role for attorneys in the pre-design process. For example, if someone is looking to make sure that they are not infringing upon someone else's intellectual property, they may ask for a patentability analysis to kind of get a sense of where the white space is in their particular area. But that does, create difficulties because if you're designing to a patent, to try to get a patent, then you run the risk of maybe you're not making the best design choices for the technology itself. So typically it starts at the point where the client is aware that they have an invention and they will contact an attorney, typically a patent attorney, to develop a patent strategy, which will involve a prior art assessment, determining, what is this thing going to be patentable? What types of claims might be available for the invention? And developing a strategy of where to file, when to file, and the timing of those filings in connection with any sort of public disclosure.
So you gave us a couple things to think about. Would you say that patents are the most popular area where the law and medical technology intersect? Do you think that that's what most lawyers who are interested in this specific area will spend most of their time doing?
Yes, except for the business aspects. So those two things are kind of go hand in hand, because even once you have a solid patent application filed, if there's not a path to market for the invention, then it's not going to go anywhere.
Mm.
So having an understanding of the business process for getting the invention to the marketplace is also critical. But patenting is the first step. Other forms of intellectual property are important as well. Some companies may try to keep some types of medical technologies as a trade secret. That doesn't work quite as well in the medical technology field because of all of the regulatory approval that's needed. But there may be certain aspects that are appropriate for trade secret. And then trademark is also a very important area. And so this kind of goes more into the pharma and biotech, where naming and branding is really critical for drugs and therapeutics. But medical devices as well typically are branded. And so understanding trademark law and how that intersects with branding is important.